believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't. Counsel, we have somebody that may have tested positive for COVID this morning. So if you want to wear a mask, you're certainly welcome to do so. What your objection is, or what your statement is in terms of your motion to recuse, I'm going to deny it.
Aren't you interested in removing the cloud that's hanging over the case right now, Your Honor?
Sir, I'd be real careful about.
If you're new, make sure y'all hit that notification bell, that like, share, comment, and subscribe. Grab a seat. We finna dig deep. What's up, YouTube family, and welcome to the channel. I'm your host, Jay, and man, today we definitely got to take a deep dive into this Young Thug YSL Rico trial. Now, with the recent rulings coming down from the Georgia Supreme Court, ask yourself, were these rulings being favored for the defense or a costly mistake for the case? Man, before we dig deep, y'all make sure y'all hit that notification bell, hit that subscribe, and definitely hit the likes. Without further ado, y'all know the vibes, grab a seat, we finna dig deep. Now, since this week has been going, it seems like a lot of this case has actually been weighing on the actual judge instead of the state. Now, this evidence that the state has been introducing through this week has definitely come off to be more prejudiced and probative. But ask yourself this, with these rulings and the motions that are being filed by the defense and the counsels for those of the YSL team, is Judge G actually being biased, or is the defense just doing their job? Now, the interesting thing is, over the past few weeks, we've seen several of the defense attorneys actually file motions asking that Judge G be recused from the case or either be sworn in as a witness due to the ex parte. Now, is the judge actually acting in good faith and just doing his job? Or will the judge's decisions actually be noted as costly mistakes? Which brings us to where we are today, the recent ruling by the Georgia Supreme Court. Now, ironically, the actual motion was actually passed by the Georgia Supreme Court and reads as follows. Petitioner DeMonte Kendrick, who is facing trial on murder and other charges in Fulton County, filed directly in this court an emergency motion seeking original relief in the form of mandamus against Chief Judge Uriel Glanville, aka Judge G. In a stay of proceedings, Kendrick filed in the Superior Court a motion of recuse Chief Judge Glanville after he became aware of an alleged ex parte meeting on June 12, 2024. Now, between the judge, assistant, district attorneys, the state's witness, and the witness attorney, Chief Judge Glanville did not refer Kendrick's motion to recuse to another judge, see Uniform Superior Court Rule 25.3, and instead decided the motion himself and denied it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
Now, this is huge for the defense. Now, peep this. Now, because of the ex parte meeting, which at this point nobody can deny actually happened, which we also going to talk about those transcripts as well momentarily, but right here in this actual motion or the response from the Supreme Court, with this small one right here, if you pay attention to the small print, which I'm about to read, you'll see how this is significant, because you have to ask yourself, is the judge actually being biased, or is he actually overstepping his boundaries? Let's dig. USCR 25.3 provides that when the trial judge is presented with a motion to recuse or disqualify accompanied by an affidavit, the judge shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness of the motion and the legal sufficiency of the affidavit and make a determination, assuming any of the facts alleged in the affidavit to be true, whether recusal will be warranted. If it is found that the motion is timely, the affidavit sufficient, and that the recusal will be authorized if some or all of the facts set forth in the affidavit are true, another judge shall be assigned to hear the motion to recuse. Now, what's interesting is this part right here. In his emergency motion, Kendrick does not seek an appellate review of the order denying his motion to recuse. Instead, he seeks original relief from the court against Chief Judge G, asserting that any effort to file a petition for writ of mandamus in the Superior Court will result in frustration from Judge G and lack of action because of such a petition will go to Judge G for approval. So he has no option other than to actually file it with Georgia Supreme Court. That is crazy in itself to be filed in a motion. Now, the other key element that stood out in this whole response from the Georgia Supreme Court is that right here, as you see, Weinstein and the defense are both asking for an unredacted transcript of that secret ex parte proceeding that was held on June 12th. Now, before we break this down, let's talk about the response from the Georgia Supreme Court. Now, right below there, you see that it says that although this court has the power to grant the original relief in the nature of mandamus, it has chosen to maintain its general status as an appellate court and to exercise its original jurisdiction only in extremely worse circumstances. So what does this mean for the case? Let's talk about it. Yo, stop what you're doing real quick. Hit that like button and subscribe to the channel. It's free. Hit the like button. Share the video. Hit the like button. Let's dig. Now this was a huge W for the actual YSL defense and definitely Weinstein. So you gotta salute and give his credit where credit is due. However, it's always something with this YSL trial. Now here's the shocking twist. Although the Georgia State Supreme Court judges 11 out of 12 agreed, the 12th one decided to not participate. Take that for what it's worth. But why were the motions filed in the wrong place? Now this was crazy because even though the motions were filed and the Georgia State Supreme judges agreed, Judge G has to be the one to approve for it to actually go up to the actual Supreme Court judges. So this actual motion with him actually winning and them being in agreement that, hey, Judge G actually stepped over his ground and his boundaries and this is a potential conflict for the case, ask yourself this. Were the attorney's movements actually strategic for the case? Because for a lot of people actually questioning, did he drop the ball or was his actual strategic planning? In my personal opinion, I say the defense actually got the W. Here's why. With the Supreme Court judges 11 out of 12 actually saying, hey, Weinstein, you are absolutely correct. Bing. Guess what? Even though we are all in complete agreement and it has to go back to Judge G for him to actually be the one to approve it to come back up, guess what? They also gave him all the fundamental legwork case laws that he needed if he wanted to make it even stronger to do it. So in my personal opinion, I feel like the state actually dropped the ball and actually just got played. And in order for YSL members and the attorney and the defense to actually win this case, every attorney has to actually do their part. So ask yourself again, did Weinstein drop the ball or did the defense just catch a break? So was this filing error a strategic move by Attorney Weinstein to test the court's response or a costly mistake that could impact the entire YSL defense? Now again, that's just my personal opinion. And again, I haven't been wrong yet. This was an actual strategic move, not a mistake. But what is clear is that the Supreme Court is definitely in agreement with the motion, despite the actual filing location. Because there's no way possible you got this entire YSL defense team over there that knows that this was being filed and everybody decided that, hey, we'll skip this one step. No way possible. So that's why I say that in my personal opinion, this was a strategic move, not a mistake. And the real question is now that that information has been exposed, what about the information that's in the redacted ex parte? Now, it's another whole situation that we're about to jump into as soon as the week starts. But why is the defense getting an edited or redacted version of the actual ex parte transcript instead of the original version? I feel like the defense actually filed some valid motions that actually have valid points. Definitely an interesting situation, and we'll be keeping a close eye on this case as it continues to develop. So y'all make sure y'all jump in the comments. Let me know y'all's thoughts with this whole motion. Was this a W for the defense or an L for the state or vice versa? Y'all make sure y'all hit that subscribe and hit that notification bell so you'll make sure you catch those drops whenever we drop as well. Man, y'all know the vibes. Until next time, it's your boy Jay. And remember, the life you save might be your own. This case is a very example of what's going on. Until next time, gone.